Democratic Convention last July. In this report, Paul Strand recaps that story and brings us up to date on this shocking legal battle.
Operation Rescue members have a radical technique for shocking people with the gruesome reality of abortion. They confront them with actual aborted fetuses. That's what Randall Terry and other Operation Rescue leaders said they planned to do to Bill Clinton sometime during the week of the Democratic Convention. And as the headline showed, on July 14th, that's just what one of their members did. The problem was, hearing of their plan, the New York District Attorney General got a judge to put out an injunction forbidding them from confronting Clinton with a fetus. So arrest warrants went out for 7 Operation Rescue leaders, and they surrendered themselves at the federal courthouse in New York City, July 16th. First, though, they had to face a wild gauntlet of screaming, jeering pro-abortion radicals who kept up such a racket the pro-lifers couldn't address the media. Inside the courtroom, the judge behind the injunction decided to let most of the defendants off with simple civil charges. But he tangled with Randall Terry before, and to teach him a lesson, he announced the Operation Rescue founder would have to face full criminal charges, which could mean years in jail and hefty fines. The trial was postponed until this week. The American Center for Law and Justice has gathered 6 attorneys to represent Terry. Wednesday, they tried to get the pro-choice Attorney General of New York knocked out of the case. They claimed Robert Abrams showed up personally at an Operation Rescue abortion blockade this last April and made insulting gestures at Randall Terry, as well as yelling at him, "You'll lose." But the judge said he saw no reason to remove the Attorney General or his staff from the case, so it begins today with the prosecution ready to call 15 witnesses over the next several days. Paul Strand, CBN News.
Well, joining us now from the Federal Court Building in New York to give us the latest is American Center for Law and Justice Chief Counsel Jay Sekulow. Jay, it's great to have you with us. What did you say, what did this say to you when the judge wouldn't bump the Attorney General Abrams off the case?
Well, Pat, we filed originally a motion to disqualify the State Attorney General, Bob Abrams, because of what we deemed personal animosity and personal bias. Yesterday in court, in a 4-hour hearing, we were actually showing the court tapes that actually were used in the senatorial campaign where Attorney General Abrams stated that one of the things he'd done was prosecute Operation Rescue. And the appointment of a prosecutor for a contempt case is supposed to be neutral, as a neutral prosecutor. We felt there was complete animosity, and the end result was, and unfortunately the judge found that we didn't meet what he deemed to be the appropriate standard. I'm not surprised, quite frankly, that we found ourselves in that posture. As I've said before and we've talked about many times, this is the abortion distortion factor, where once it's abortion, it's as if the rules change and the laws change. Clear denial of due process, denial of the Bill of Rights, and that's really what's in trial in the courthouse today.
Jay, you're in a federal court. Is this a federal court you're in, New York State, federal court?
No, this isn't the federal court, Pat.
Well, you've got a clear case for an appeal then on just this one ruling. Is that not right?
This entire case is being tried for the appeal. You know, Pat, time and time again, we find ourselves in the trial courts. We saw this in Texas and other places where we'll lose at the trial court, then get it up to the Court of Appeals, and we won. Interestingly here, it was just about 6 months ago that I was before the U.S. Court of Appeals for the Second Circuit, which meets in the same building, a case we had been tried for a number of years. We lost it in the trial court, and then recently the Second Circuit unanimously reversed us. So it's the kind of case, and this case today is the type of case where you've got to go pursue justice in the name of the Lord, and that's what we're doing here. We are, in one sense, it is a David against Goliath. They've got a complete arsenal of weaponry, if you will, against us in this case, and we're going to present our case, set the whole case up for appeal, and pursue justice. One of the lawyers, Pat Monahan, our senior counsel for the center, said this case has got a Supreme Court earmark, and I think that's true.
Jay, you're pitching it totally as a free speech case. That's going to be your complete argument here?
Absolutely. I mean, the fact of the matter is the alleged event, which Randall Terry really had nothing to do with, but the alleged event took place on a public street in New York City. Public streets and sidewalks are public forums. And Randall Terry's alleged involvement, which we say, I want to preface that by saying alleged, would have been free speech conduct. So far, the court has not accepted that argument, but that's why we're in court today. We're going to be dealing with that, and we're going to make the state have to go through every legal loophole. Christians need to be entitled to every avenue of defense available, and that's one message we're sending today in New York, that the American Center for Law and Justice is going to ensure that the constitutional rights guaranteed to all citizens of America includes Christian citizens of America, and the state is going to have to meet its burden.
One last thing, as a public human interest. Is Bill Clinton going to have to show up as a witness?
Well, you know, the judge ruled, Pat, that Bill Clinton was a material witness. The decision was that he would not testify until the completion of the evidence, and then, since this is not a jury, we would then have the option, or if you will, of renewing our request for testimony. In large part, it's going to depend upon what happens and what they present. One of the interesting things here is there's no direct allegations against Randall Terry, yet he's the only one that's been accused of criminal contempt. This is, in one real sense, a political trial, but we're going to make sure that the laws are complied with and do our best to defend it, get the case ready for appeal, and go up to appeal if necessary.
You've got 6 lawyers up there with the American Center. You're not going in there unprepared.
Absolutely not. We've got 6 lawyers here. Pat Monahan, our senior counsel's here. John Stepanovich. We got 2 lawyers, Jim Henderson and David Etheridge from our D.C. office. Stu Roth came in from Mobile. We've got a full group of lawyers. I will say also, so do they. It's going to be, all counsel tables are full in this case, Pat, on both sides of the argument. But we went in yesterday, and I'm got in every piece of evidence we needed to get in, and we met clearly the precedents of the U.S. Supreme Court on disqualification, but the court held against us, but we're going to keep going forward. We've been in these so many times where you have this at the trial court and then you go up on appeal, but I am still confident. Ask everybody to pray for a victory right here at the trial court.
Jay, thank you very much. And ladies and gentlemen, I will echo what Jay Sekulow and his team are saying. That's a fabulous thing, but you wouldn't see 6 top constitutional attorneys coming into court in a civil rights or civil